Welcome to the Oregon Family Law Series. Today we're talking about whether your child can talk to the judge, and we're talking about a child that is at issue in the case. Okay, this is a common question. It comes up a lot, and there's a statute on it. It's ORS 107425. You could look it up. You're looking at the beginning of the statute here, and this is the end of the statute. And this is the portion that relates. And you can see that a motion is required to arrange this. Now, usually the second question that comes up is whether the child will have to talk to the judge in front of the other parent. And you can see in the statute here that the judge is specifically empowered to exclude parents from the conversation. And this happens all the time. I've never seen a judge talk to a child in front of a parent. In fact, normally there are three situations. So usually a judge is going to talk to the child in private, just the judge, the clerk, and the child, unless both parties have an attorney. If that is the case, then the attorneys will be given the option to sit in on the conversation and ask follow-up questions once the judge is done. Now, the other questions that also come up relate to age as well. People want to know, is there a minimum age that the child has to be to speak to the judge, and at what age do the children get to choose where they live or what the parenting plan is? And there is no statutory guidance on what age a child has to be to speak, so it is totally up to the judge. They have full discretion. I have never seen a judge talk to a child younger than 8. Most judges prefer to talk to children 9 and above. I'm not saying that it's impossible for a judge to speak to a child younger than 9. I'm just saying I don't normally see it. You can always ask. The worst that can happen is a judge can say no. As far as picking their residence or their parenting plan, children never can do that. As long as they are subject to the custody jurisdiction of the court, the decision is up to the judge. But that said, what I also see is that when judges talk to older children, especially teenagers, if they are well spoken and they have solid reasons for what they want, the judges will take that very seriously, and that can be the decisive factor in a case. Okay, so now we know that you need to file a motion to make this happen. And normally when a motion is required, I refer people to the Form Center on the website of the Oregon Department of Justice at courts.oregon.gov. But as of this recording, there is no form for this in the Form Center. So what you can do is you can use a generic motion and order and adapt it to this purpose. And there is a good generic motion and order on the website of the Jackson County Circuit Court. So let's take a look at that. Okay, so here we are on the website of the Jackson County Circuit Court, and you're going to use this blue bar on the left side of your screen. You're going to scroll all the way down to local forms. And when you get to local forms, you're going to be looking for family law, which is right here. And once you get into family law, you just want the second packet down. It says civil, family, small claims, generic motion, order certificate. You're going to click on that. And this is a good generic motion and order form. You can download it right here and fill it out the way you want. There are instructions right here. That's the first page. But I'm just going to take you through and show you how to fill this out as well. So you're going to fill in the caption. And right here where it says motion and declaration in support of motion 2, you would write, have the judge speak with the child. And you would fill all this out. Right here where it says for the following reasons, this is where you make your case. Maybe you're going to write, my child is really intelligent, he understands what's happening, and I think it would be helpful for the court to talk to him so that it could craft an appropriate parenting plan. Then you're going to sign it, you're going to fill out the certificate of service, and this is the order. You're going to fill the order out the same way. You do not check either of the boxes that say granted or denied. The judge will check one of those boxes when they make their decision. And once you've filled out the motion and order, what I do is I send these to the other side so that I can get their position on the motion. And once I get their position on the motion, then I can fill out page 3, which is the certificate of readiness. And if you
If they agree in writing, you want to put that on the certificate of readiness. If you can't get their position, the safest thing to do is to just say, I can't get their position, so the court will need to make a ruling. And then you can submit it all to court. And if you submit it with a certificate of readiness that says the other side agrees, normally the judge will just go ahead and sign the order. If you submit it with a COR that says the other side objects, then normally this motion will get set for hearing, and then at that time the judge can decide whether or not the order will be signed.
Okay, just a few voice of experience tips. It's always a good idea to prepare your child for what's going on, but do not coach your child. If the judge feels like you've done that, that will be a huge problem for you. It's also a good idea to have your child make some of their own notes so that they can remember everything they want to tell the judge. I have seen children become so starstruck coming into the building that they literally forget everything they want to tell the judge, and it didn't work out at all. In addition, judges do not like to have children waiting around outside the courtroom, so don't be afraid to contact the judicial assistant to find out whether or not you should bring your child to court. If you have someone who can help you out by standing by to bring your child to court when the judge is ready for them, that would be ideal. And then also, some courthouses in Oregon have special spaces designed for children who are going through this process, so don't be afraid to inquire with the court to see if that might be something you can take advantage of as well. Okay, that's what we have for you. Thank you very much for watching. I hope this helps you, and good luck in your case.